court, presided over by Justices Elizabeth Musoke, Muzamiru Kibedi, and Christopher Gashirabake, finally resolved a 10-year divorce case between Joseph Ambayo, Waigo, and Jackeline, Aserua, residents of Mbuya Mutungo in Kampala. In the landmark ruling, the consequences upon the sharing of matrimonial property after conclusion of a divorce are that marriage does not give a spouse an automatic 50% share of the matrimonial property. A spouse's share in the matrimonial property is dependent on his or her contribution to it. One's contribution to a marriage can be both monetary and non-monetary, or both. Non-monetary in terms of unpaid care rendered by a spouse during the marriage, like caring for children, elderly, sick relatives, household chores, and cultivating food for the family's subsistence, among others. Where one party has in the course of the marriage contributed towards upgrading the other spouse in terms of educating him or her, such contributions should be deducted from the beneficiary spouse's total claim. Article 31, subsection 1 of the Constitution provides equal rights to husband and wife during the marriage and dissolution. Rita Mujuni, an advocate, says there is no mathematical formula to quantify how much one should get when it comes to sharing of matrimonial property when the marriage is dissolved.
Whereas one court was saying that you should do 50-50 because the law now says equal parity. Equality is equity, as they say. The Court of Appeal was of the opinion, and they also agreed with a previous decision with the Court of Appeal in Kenya, that was to the effect that it is not that easy. The circumstances of each case should determine the outcome.
The Court of Appeal is seen as being progressive by recognizing that one's contribution to a marriage can be in either monetary or non-monetary form. The quantifying of non-monetary contribution being doing domestic work, taking care of children, cultivating food for the home, and caring for the sick members of the family, according to Victoria Mufumba, a strategic litigation officer with the Uganda Association of Women Lawyers, FIDA Uganda, will have an effect on the institution of marriage.
The sanctity of marriage is being diluted or played around with when we have to tie unpaid care work to a certain market value, which we do not even have.
Members of Parliament also weighed in on the matter.
How much are you going to pay me for having sex with my husband? Does the church even allow that? How much are you going to pay me for ironing your shirt every day? So if we've been married for over 50 years, you're going to pay a dry cleaner in your wife. How much are you going to pay the women for being chefs, for being nannies, for changing diapers? I think for me, that totally fell short.
Our judges are very correct. You know, we have other women who are target workers. There are other women who get married strictly targeting the property of that particular man.
Mujuni says that evidence before a court of law is usually primary, but in matters where there is none, then the court can look at the secondary and collateral matters. Many Ugandans think that having receipts as evidence of their contribution to the marriage, in case they ever are in the courts seeking a dissolution of marriage, is a solution.
If I got a client who had receipts and showing that I bought this amount of juice on this day, and I used this amount of money, or on the basis of equal distribution of resources, I would bring in, say, 500,000 into the home in a week. That information would be of great evidential value in a court of law, but not necessarily in a marriage. So you might want to be careful.
Then there is the ruling on where one party has in the course of the marriage contributed towards value addition to the other, say upgrading their spouse in terms of educating them. The court said that such contributions should be deducted from the beneficiary spouse's total claim.
It seems to me to be the biggest issue. It's not enough that I have increased your value in terms of education. But if I feed you well enough and you then start looking healthy, and every time you step out, they compliment you and you look good, and do I not then take that into consideration? If I am not the kind of gentleman who gives you distress at home, and every time you show up at work, you're even more productive and you are happy, and you'd be a delight to be around. I myself, knowing that that's not really an easy feat, would take that into consideration.
According to the facts of the case, Aserua and her husband Ambayo started cohabiting in 1989 when she was 19 and he 24. The Constitution does not consider property which a couple acquired during their cohabiting period as matrimonial property. Rita Kanya Mujuni, NTV Tonight.